Going to discuss another specific rule you can use to determine someone's compensatory damage, which is loss opportunity remedies. In the Liberty National Life Insurance Company case versus Sanders, the underlying cause of action here again is both contracts and torts, because we have a life insurance agreement as well as fraud. But the actual basis of the claim was more fraud, not breach of an agreement, right? Even though you see both of these issues kind of appearing in the case. And the specific rule governing the measurement of damages in this particular case related to torts, fraud, was on page 568, paragraph 2. The court stated the measure of damages resulting from fraudulent conduct or representation is fixed by the amount which would have placed the defrauded person in the position he would occupy if the representations had been true. And to kind of figure out what the damages were for Sanders, we kind of have to discuss what happened. And so here, Sanders had purchased a $10,000 life insurance plan for her son who had a brain disease. And this life insurance plan included a 3-year waiting period before it would pay her that full benefit of $10,000. Sanders' son died before the 3-year waiting period was up, and she received the sum of the premiums then paid plus 10%, which was only $193.30, because at the time she'd only paid one premium of $192. So he died within the first year of this life insurance plan being executed. And so Sanders rejects his payments and claims the agent that handled her case never even told her about the 3-year waiting period, and that if she knew about it, she wouldn't have even bought the policy. The court acknowledged that the agent failed to tell her that she had purchased this modified ALX policy plan for her son, which had the 3-year waiting period because the son's brain disease disqualified him from the 10K policy without a waiting period. And so none of this was told to Sanders. So the court substantively said Sanders had a claim. The issue was just how much do they need to give her to make her whole again, as if the harm had never occurred. Remember that general rule to compensate the plaintiff. And here the court determined that the amount that would compensate the plaintiff is the difference between the value of the policy as represented and the value of the policy in reality. So that was 10K, which was the policy without the waiting period as represented by the agent, versus the $193.30, which is the premiums paid plus 10%, which is the value in reality, which meant her recovery is about $9,806, right? So about $10,000. And the jury awarded her $10,000 plus a bunch in punitive damages, which the court didn't address, at least in this opinion, or it's not in this book, because we're really just dealing with the compensatory damages and loss opportunity. So Sanders gets compensatory damages that makes her whole again, but did the court also give Sanders a loss opportunity compensatory damages? The answer is no, because Sanders already received the full benefit of her bargain by getting that almost 10K back, the value of the policy as represented. And although the defendant said she didn't prove loss opportunity, the court clarified that plaintiffs don't have to prove every type of damage to recover compensatory damages. Sanders just had to prove one of these specific rules applied in order to collect her damages to make her whole again. But let's pretend for some reason she was unable to prove there was fraud and there was a difference between the value of the policy represented and the policy in reality. Could Sanders have proven loss opportunity damages and collected those instead? And the answer is yes. And on page 70, the court states, well, Sanders could have purchased a policy with substantial coverage without the 3-year waiting period from another insurance company, specifically citing United America, that would have given her $2,500 for the death from natural causes in the first year for her son. But the reason she didn't go for this loss opportunity damages is we're looking at $2,500 versus $9,800, right? The measurement of the loss opportunity damages based on the evidence here is only $2,500, but the measurement of damages resulting from fraudulent conduct, which was a specific rule we discussed in the very beginning of this lecture, well, that gives her way more, and that would fully compensate her. So that's why she opted to go for this specific rule that deals with compensation that was on page 568, paragraph 2. So what's the rule for loss opportunity damages? Well, the rule you need to commit to memory is a plaintiff is awarded lost opportunity damages if the defendant's breach of contract or wrongful act has deprived the plaintiff of an opportunity to enter to either avoid a particular loss or to obtain a particular benefit, right? So if you're able to prove that, then you're able to get lost opportunity, and then you move on to calculating, well, how much is that lost opportunity and measuring the damage.